2023 SCMR 6. Present, Qazi Faiz Isa, Yahya Afridi and Jamal Khan Mandokhail, JJ. Munir Hussain and others, applicants. Versus RIFFAT Shamim and others, respondents. Civil Miscellaneous Application Number 3492 of 2022 in Civil Petition No. Nil of 2022, decided on the 14th of November 2022. A Specific Relief Act I of 1877. S. 42 Paternity of Child, suit for declaration challenging paternity of a child. Suit was filed about 7 months after the death of the child's father, and at a time when the child was aged about 17 years. Admittedly, child was brought up by and his wife the respondent as their daughter, and as long as lived, the child's paternity was not questioned by the plaintiff's petitioners, who, for the first time, did so after the father had departed from this world. Respondent mother testified that the child was her and AH's daughter. Petition for leave to appeal and application were dismissed. B. Specific Relief Act I of 1877. S. 42 Paternity of Child, suit for declaration challenging paternity of a child. Maintainability. Through their declaratory suit, the plaintiff's petitioners sought a negative declaration to the effect that the child in question was not the daughter of but of MZ. To challenge another's paternity legitimacy is not an assertion of one's own legal character in terms of Section 42 of the Specific Relief Act, 1877. However, a person whose legal character, including paternity, was being denied, such person could file a suit to claim it, but the present case was not such a case. Plaintiffs lack legal character under Section 42 of the Specific Relief Act, 1877. Petition for leave to appeal and application were dismissed. Order. Qazi Faiz Isa, J. SCMR. No. 3492 2020 seconds. Through this application, the petitioners seek permission to array Tuber Sahab, respondent number 2, as the daughter of Muhammad Zarif. 2. The petitioners had filed a suit alleging that Tuber Sahab was not the daughter of Azza Hussain but of Muhammad Zarif. However, the learned judge of the High Court held that Tuber Sahab was in fact the daughter of Azza Hussain. Nothing much turns on this application, as the petition for leave to appeal has been filed within time and the application could only be granted if the impugned judgment of the High Court was to be set aside. Therefore, even though the petition for leave to appeal has not been numbered V, after the learned counsel said he was ready to proceed with the case on merits, proceeded to hear the petition. The officers directed to number the civil petition for leave to appeal CPLA 3. CPLA No. 3842 2020 seconds. The learned counsel for the petitioners states that the petitioners are the siblings of Azza Hussain, who died issueless on the 4th of June 2013. The learned counsel submits that Azza Hussain adhered to the Sunni Hanafi fiqh of Islamic Sharia. Therefore, if Tuber Sahab is taken to be the daughter of Azza Hussain, then their share in the estate of Azza Hussain would be significantly reduced. It is admitted that Azza Hussain was married to RIFFAT Shamim, respondent No. 1. The case of the petitioners plaintiffs in the suit was that Tuber Sahab was actually the daughter of Muhammad Zarif and not of Azza Hussain. The suit was filed on the 29th of January 2014, that is, about 7 months after the death of Azza Hussain and at a time when Tuber Sahab was, as per learned counsel, aged about 17 years. Admittedly, Tuber Sahab was brought up by Azza Hussain and RIFFAT Shamim as their daughter, and as long as Azza Hussain lived, her paternity was not questioned by the petitioners, who, for the first time, did so after the father, Azza Hussain, had departed from this world. The mother, respondent number 1, testified that Tuber Sahab was her and Azza Hussain's daughter. 4. The learned judge of the High Court had referred to a number of decisions, including the decision in the case of Lala Qayyum v. Fawad Qayyum PLD 2019 Supreme Court 449, which had considered in detail the scope of a declaratory suit filed under Section 42 of the Specific Relief Act, 1877, and like in that case the paternity of another was denied by the plaintiffs. In other words, the plaintiffs' petitioners herein through their suit sought a negative declaration. After considering the scope of the said Section 42 in precedents, this court held in Lala Qayyum's case that to challenge another's paternity legitimacy was not an assertion of one's own legal character in terms of Section 42. However, a person whose legal character, including paternity, was being denied, such person could file a suit to claim it, but the instant case is not such a case. In Lala Qayyum's case, the plaintiffs lacked legal character under Section 42 of the Specific Relief Act, 1877, and the same principle is attracted in this case. The learned counsel has also not been able to distinguish the decision in Lala Qayyum's case from the instant one. 5. In the impugned judgment, the learned judge had correctly applied the law, which had been interpreted in the case of Lala Qayyum. Therefore, to grant leave is not warranted and, consequently, the petition numbered as CPLA No. 3842 2020 seconds and CMA No. 3492 2020 seconds are dismissed, but with no order as to costs, as caveat was not filed by any respondent. Copy of this order be sent to respondents numbers 1 and 2.